The coin market cap is used to summarize everything that is said in this movie. Also, don't forget to like and subscribe to my station to get more XRP news and news about cryptocurrencies in general. Look at this now. Dates for the XRP lawsuit were announced as worries of an SEC shutdown grew. The U.S. Court of Appeals just released an important set of dates for Bradley Sostak's explosive lawsuit against Ripple. The U.S. Securities and Exchange Commission (SEC) is working hard to turn in its main brief before Chairman Gary Gensler leaves his job, even though a lot is going on. But there is a chance that delays will happen if the government shuts down. That's the reason. In your case, Ripple, the U.S. Supreme Court's appeals file has said important dates. Bradley Sostak, the plaintiff, has been told by the U.S. court to send a settlement question by around December 23rd. Right after that, the court expects to get the review's transcript order by December 31st and the whole transcript by January 30th. Sostak will then send in his opening brief on March 6, 2025, which will include all of his claims against Ripple and the CEO of the company, Brad Garlinghouse, even though Garlinghouse, Ripple Labs, and XRP are supposed to answer by April 7, 2025. If either party doesn't meet these dates, the appeal might not be valid anymore. Recently, the court has made several decisions that have been good for Ripple. The most recent statement comes after these decisions. Even though this is happening, Bradley Sostak is still going ahead with his claims. Just recently, Judge Phyllis Hamilton agreed to hear a motion that wanted to change the ruling and the stay in the case. Both sides agree that the ruling didn't need to be put off, because the class claims were already over, and they wanted a new order to take this into account, getting ready for the sexy shutdown. At the same time, the Securities and Exchange Commission, which is also taking part in the case against Ripple, is having its own problems. A possible shutdown of the U.S. government is getting closer and closer because of worries about money. The Securities and Exchange Commission may take longer to respond to the appeal because of this problem. Some analysts have even said that the ongoing court battle may be put on hold. There is a chance that this delay will help Ripple deal with some of the stress it is currently facing. On the other hand, it could also delay any solution that would make the management of XRP clearer. It says in the notice of appeal that was filed in the district court that a court of appeals in the U.S. has set more times for the case against XRP, is due on March 6, 2020, and Ripple Labs XRPU and CEO Brad Garlinghouse are due to respond to the appellant's major brief by April 7, 2020. The U.S. Securities and Exchange Commission is getting ready to send in its main report before Gary Gensler leaves his job as chair of the Securities and Exchange Commission. The U.S. Court of Appeals for the Ninth Circuit gave the case that Ripple was involved with a docket number after making sure that it had gotten notice of the appeal. The Court of Appeals asked that any move to get help from this court be sent in a different way. The plaintiff has 14 days from getting this notice to file a disclosure statement, which is similar to filing an appeal with the U.S. Securities and Exchange Commission. This is because the relevant papers were not sent to the appeals court. The challenge in the XRP case should be thrown out. Bradley Sostak, the plaintiff, has until December 23rd to turn in the mediation form according to the order that was made. Both the order for the appeal transcript and the appeal transcript should be turned in by December 31st and January 30th, 2018, respectively. The plaintiff will have to file an opening brief on March 6th. This will set the stage for the claims that will be made against Ripple and CEO Brad Garlinghouse. Ripple Labs, XRPE, and Garlinghouse have until April 7th to send in their appeal answering papers. Section 103 of the Ninth Circuit Rules of Procedure says that if there were reported meetings, both sides must name and cross-name the transcripts. The court thinks that the dates for transcripts don't apply if there were no hearings that were reported. Coingate already reported that the main suit, Bradley Sostak, filed an appeal against recent decisions that sided with Ripple Labs, XRP, AI, and CEO Brad Garlinghouse. There was a win for Ripple in the district court. As for the XRP case, Judge Phyllis Hamilton agreed to the request to change the order about judgment and stay. Both sides sent the court a proposed order saying that there was no need to delay the ruling as the class claims had already been dealt with. People are paying attention to the case of Ripple vs. SC, which is being heard in the Second Circuit Appeals Court right now. People who work for Ripple and people who are interested in cryptocurrencies are hopeful that the case will be dropped or withdrawn. Some people are worried, though, that Gary Gensler will make things more difficult when he steps down on January 20th, which is 5 days after the deadline for the main brief. As the January 15th hearing date gets closer, the court battle between Ripple and the SEC has been getting better. John Reed Stark, a former enforcement official for the Securities and Exchange Commission who is now a crypto skeptic, was recently on the Docket Media LLC podcast to talk about the important decisions on Ripple. The Ripple verdict does not give wide legal certainty, he said. It should only be used in cases with specific facts that are similar to those in the Ripple case. In his criticism of the Ripple ruling, he said that a lot of people didn't understand what it meant, probably because they hadn't read it all the way through. He said that Judge Torres was wrong in more than one way, which is also what other judges who have looked over the case more than once have said. A lot of people get the Ripple decision wrong because, in my opinion, they didn't read it. It is not at all. With all due respect, I would like to tell the court of Torres that I think she was wrong on several points, just like Judge Rakoff and every other court that looked at that decision. His words and Stark's point of view made it clear that the choice about Ripple was split. For starters, he agreed with the argument that the first sale of XRP tokens to experienced buyers should have been registered as a security to protect those people. On the other hand, Stark didn't agree with the choice about the secondary market, which is where XRP was traded on exchanges. Stay ahead of the game in the Ripple vs. Sex drama by reading the XRP price prediction and learning about what could happen in this legal battle for the market. The choice that Ripple made was not clear. Putting forward the claim that small investors were not protected because Ripple did not deal directly with them is not fair, in his opinion. He doesn't think this line of thinking is fair. Stark said it was different from buying stocks in a company where investors don't have a direct contract with the company but are still covered by securities laws. Stark also said that the Ripple ruling was unfair because it created confusion, especially after companies that back cryptocurrencies used it to say that tokens were not securities but cryptocurrencies. As a result, the Securities and Exchange Commission gave up the interlocutory appeal in order to end the processes that were already going on.